from Georgia is recognized for 5 minutes.
Thank you, Mr. Chairman. And before I begin, I'd like to ask unanimous consent to submit a letter to record from the Electronic Transactions Association. Okay. I'd like to ask unanimous consent to submit a letter for the record from the Electronic Transactions Association.
Without objection, so ordered.
I've used 30 seconds of my time already. Mr. Bland, just a couple of questions. I noticed your history of lawsuits on the back here, suing these, I guess, various banks in some form or fashion. What do you remember what your total fees were when you would sue a bank? I mean, was that a percentage, or who paid you, and who were these suits on behalf of?
So every case that I've handled where we've won and received a settlement, we have gotten some attorney fee. I mean, I'm with a nonprofit, but we've received some attorney fee that's based on a percentage of what we recovered. So, for example, in the case against Chevy Chase Bank, where they misled people about the credit cards, we got a $16.1 million recovery. I think the attorney fee in that case was 20%. It was approved by a court. There was a big argument about whether that was fair. We had to come in and show that we had worked more hours, and then it was based on a percent. In the cases in North Carolina involving payday lending, they're on my resume, where we recovered $45 million for consumers and sent it out in checks. I think in that case the court approved 30% fee in the first case because there had been a lot of work, and then in the other cases approved a lower percentage. I think it was 25%, and it was approved by a court, and there was a lot of debate and discussion about it. And so it's generally done on a percentage of the case, but then you also have a cross-check with what your hours are. So before a court will approve it, you can't just come in and say, I want 20% of, whatever.
Yeah. And I'm assuming part of your cost is mailing out all these letters to the different people. I get a letter almost once a week asking me to join some type of class action lawsuit. Is that what you do, solicit business that way?
No, I've never engaged in advertising. People come to us and ask us.
Well, that sounds like pretty good pay for a nonprofit. But, I just had a case where I had a problem with a charge on my credit card. I called, told them what the problem was, and she said, well, I'm sorry, you didn't read the fine print or whatever. And I said, fine, I'm just going to take it to the credit card company. I was talking to the retailer, and they said, well, would you pay 30%? And I said, yes, I would. And so she said, do you agree to that, knowing blah, 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 blah? I said, yes. And so we settled it because it was a misunderstanding. And this class action thing, to me, is taking that right away from somebody that's trying to do something or arbitrate or mediate their problems. But whether it's a woman trying to get it's got an error on a $25 prepayment card, or a small business owners, if any of these situations, I'd like to get my problem solved as soon as possible so I could go ahead and pay my debt. Professor Johnson, I know you've looked at data on how companies handle customer issues. Can you describe why companies may want to resolve a claim quickly?
Yes. The reason is by sometimes admitting they made a mistake and refunding a charge. What do companies do? They basically make their customers happy. They do the right thing, and that builds business. The CFPB, in the report, in their study, and also in this proposed rulemaking, continually asserts that the only reason a company would ever refund a charge is because it's a super profitable customer. Now, this assumes they have really, really fancy algorithms or something. But the important point for present purposes is the CFPB has no evidence of that. They simply say, they assert, economic theory suggests that the only reason you'd refund a customer is because profitability demands it. In the CFPB's world, fairness to consumers is opposed to profitability. In the real world, as far as we know, by being fair to consumers, companies build profitability.
Well, that seems to be the CFPB's MO. And just to make sure, Mr. Pincus, you mentioned in your testimony, but not every problem or claim like the ones I just mentioned are able to join a class action lawsuit. Is that correct?
That's exactly the problem. Those people, those claims are individualized, and so they can't be litigated in class action.
Unless somebody like Mr. Bland mails them a letter and asks them to join a class action lawsuit because they may not even know there's a class action lawsuit.
Although even if they do, the court will likely, that'll be one of the 87% that's thrown out because it's not a common issue among a lot of people. It's your particular problem that you want to resolve that isn't common to the other 100,000 people or whatever it is.
Thank you, sir, and I yield back.
Let the record reflect I gave the gentleman his 30 seconds.